day, ladies and gentlemen, Joy Stephen once again with a case law from the Palinsys Studios. Case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system is not fair or to gain an understanding of the recourse available in Canada in case you have a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. Gulamsakhi versus Canada. It's an immigration, refugee status, procedural fairness. Refugee applicant was citizen of Afghanistan who applied for refugee protection on basis of her fear of domestic abuse by husband. After being allowed visit with her family in 2011, claimant's brother obtained Chachikra primary identity document used in Afghanistan for claimant, which he used to obtain Afghan passport for the claimant. Claimant's brother helped her to escape from her husband's home, and she traveled to Uzbekistan and from there came to Canada with Pakistani passport and made refugee claim. Claimant's family was subsequently beaten by militia sent by husband, and claimant's brother was kidnapped. Claimant's husband falsely reported her to Afghan authorities for running away with another man, and claimant alleged that if she returned to Afghanistan, her husband would kill her for dishonoring him and that she may be arrested and imprisoned for adultery. Refugee Protection Division (RPD) found claimant had failed to establish her personal identity due to lack of credible documentation regarding Tazkira. On hearing, claimant requested documentary evidence on critical issue of identity. After discussion with counsel, RPD refused this request and issued its decision following day, rejecting claim for refugee status. Claimant did not have benefit of any form of risk assessment under either SS 96 or 97 of Immigration and Protection Refugee Act, Canada. Claimant applied for judicial review. Application granted. Decision of RPD set aside. Matter remitted to be determined by different constituted panel of RPD. RPD erred in refusing to grant claimant adjournment or permission to file evidence later. All adjournments require balancing of many circumstances of case. Here, primary error was that RPD did not factor into its balancing consequences of deportation of this claimant. It was obvious from transcript that RPD's request for other identification documents came as surprise to claimant. At no time during hearing did RPD identify concerns it had regarding Tazkira, which it later enumerated as its reasons. Given potentially horrific fate awaiting claimant, not only at hands of her husband but also the hands of the criminal and possibly religious justice authorities, and given little prejudice adjournment would realistically cause RPD or Canadian authorities. Overall fairness required RPD to grant adjournment to enable claimant to provide RPD with corroborating documents it requested. Very interesting case. Gulamsakhi versus Canada, January 27th, 2015. Thank you.